it has advisory jurisdiction and that it may exercise this jurisdiction with respect to the present request, in accordance with Article 65, paragraph 1 of the Statute of the Court and Article 102 of the Rules of Court. The Kingdom would like to emphasize that it considers that, and I quote from the advisory opinion on the construction of a wall, the object of the request before the Court is to obtain from the Court an opinion which the General Assembly deems of assistance to it for the proper exercise of its functions, unquote. Therefore, the request should be regarded in a much broader frame of reference than a bilateral dispute. And it is with such broader frame of reference in mind that the Kingdom seeks to assist the Court in answering the questions contained in the request through the identification of the applicable international law and the presentation of the legal opinion of the Kingdom on the status and interpretation of that law. Mr. President, distinguished members of the Court, the Kingdom would now like to turn to the questions posed in the present request for an advisory opinion. Mr. President, according to the Kingdom, the right of self-determination of peoples is a permanent, continuing, universal, and inalienable right with a peremptory character. The principle of self-determination of peoples is enshrined in Articles 1 and 55 of the United Nations Charter. It is also contained in several resolutions of the General Assembly with historical importance, such as Resolution 1514, which states that, and I quote, "All peoples have the right to self-determination. By virtue of that right, they freely determine their political status and freely pursue the economic, social, and cultural development," unquote. The right of self-determination has been reaffirmed by the General Assembly in Resolution 2625, pursuant to which every state has the duty to refrain from any forcible action which deprives peoples referred to in that resolution of their right to self-determination. In addition, this right is enshrined in Article 1, common to the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights. The Court has acknowledged self-determination as a right of peoples in the Namibia Advisory Opinion, the Western Sahara Advisory Opinion, the East Timor case, the Advisory Opinion on the construction of a wall, and the Advisory Opinion on the separation of the Chagos Archipelago. In the East Timor case, the Court observed that the right of peoples to self-determination is a right erga omnes. The status of the right of self-determination as a right under customary international law is thus beyond reproach. According to the Kingdom, the right of self-determination is applicable in the colonial and in the post-colonial context. The right is, however, equally applicable to peoples under foreign or alien occupation, as confirmed by the General Assembly on several occasions, such as in Resolution 51/84 and its Millennium Declaration. It appears that the right of self-determination is a truly universal and continuing right. It applies to peoples under colonial domination, peoples residing in occupied territory, and peoples living in independent states. As a result, a state that occupies territory is under an obligation to respect and promote the right of self-determination of peoples residing in that territory. The obligation to respect and promote the right of self-determination means that, on the one hand, the occupying state shall refrain from measures that impede the exercise of the right of self-determination of the people concerned during the occupation, and, on the other hand, that the occupying state shall take measures aimed at creating the conditions under which the people concerned is able to freely and genuinely express its will in regard of its future political status. As the Kingdom has observed earlier, under international law, a distinction must be made between situations in which the right of self-determination is exercised in a manner that preserves international boundaries, which can be referred to as internal self-determination, or in a manner that involves a change of international boundaries, often referred to as external self-determination. In the context of colonial domination or foreign occupation, the right of self-determination can be realized through independence, association, or integration. A prolonged occupation obstructs the implementation of the right of external self-determination of a people residing in the occupied territory concerned. In regard of, amongst others, peoples under foreign or alien occupation, the General Assembly reaffirmed in Resolution 45/130, and I quote, "The legitimacy of the struggle of peoples for independence, territorial integrity, national unity, and liberation from colonial domination, apartheid, and foreign occupation by all available means, including armed struggle." Unquote. If a struggle by a people for the implementation of its right of self-determination in the context of colonial domination or foreign occupation is accompanied by the use of armed force by such people, this use of armed force must be in accordance with international law. Mr. President, I will now address the law regulating the use of force, in particular the UN Charter and its prohibition on the use of force by states, contained in Article 2, Paragraph 4. According to the Kingdom, the prohibition of the use of force is a rule of jus cogens that applies erga omnes. Indeed, in the advisory opinion on the construction of a wall, the Court confirmed that the principles as to the use of force incorporated in the UN Charter reflect customary international law. In 1966, the International Law Commission noted that the law of the UN Charter concerning the prohibition of the use of force in itself constitutes a conspicuous example of a rule of international law having the character of jus cogens. Consequently, the International Law Commission included the prohibition of aggression in its list of rules of jus cogens. One of the established exceptions to the prohibition on the use of armed force is that of the inherent right of individual or collective self-defense, if an armed attack occurs against a state, as codified in Article 51 of the UN Charter. The occupation of foreign territory can be legitimate in the exercise of the right of self-defense in response to an armed attack, provided that the use of force is exercised in accordance with the conditions attached to this right. The substantive customary conditions are necessity and proportionality, in addition to the procedural condition contained in Article 51 to notify the Security Council of the actions taken in self-defense. In the advisory opinion on the legality of the threat or use of nuclear weapons, the Court noted, inter alia, that proportionality and necessity are inherent in the very concept of self-defense. So, if the placement of a territory under the control of an armed force is the result of a military operation in the exercise of the right of self-defense, necessity requires an assessment of whether the occupation and the continuation thereof is necessary to repel the armed attack or that alternative courses of action are available. This inherently supposes also a temporal element of immediacy. If the right of self-defense is not exercised relatively promptly, it may imply that the exercise of the right of self-defense was unnecessary. Furthermore, with regard to proportionality, the question is whether the occupation and the continuation thereof is proportionate in relation to the armed attack, both in qualitative and quantitative terms. If that is not the case, the occupation may be considered to violate the prohibition of the use of force. These conditions to the exercise of the right of self-defense apply as long as there is an occurring or imminent armed attack. Also, in exercising the right of self-defense, the occupying state must fully respect international law, in particular human rights and international humanitarian law. Mr. President, it is the view of the Kingdom that the right of self-defense can also be invoked in response to an armed attack by a non-state actor. This is illustrated, for example, by the Security Council's resolutions adopted after 9/11, in which the Security Council reconfirmed the right to self-defense in response to those attacks. An occupation which fulfills the requirements of the right of self-defense may be considered as lawful under jus ad bellum. An occupation which does not fulfill or no longer fulfills these requirements may lose its legal basis and hence violate the jus cogens prohibition of the use of force. Finally, the Kingdom underscores that occupation is an inherently temporary use of force, because if it were to be permanent, it would qualify as annexation. As the Security Council emphasized in 1967, in its unanimously adopted Resolution 242, the acquisition of territory by war is inadmissible. The Court recognized the customary status of the illegality of territorial acquisition resulting from the threat or use of force in the advisory opinion on the construction of a wall. Mr. President, the Kingdom now turns to international humanitarian law, or jus in bello, which regulates situations of armed conflict, including occupation. According to the Court, and I quote, "A great many rules of humanitarian law applicable in armed conflict are so fundamental to the respect of the human person and elementary considerations of humanity," end of quote, "that they are," and I quote, "to be observed by all states, whether or not they have ratified the conventions that contain them, because they constitute intransgressible principles of international customary law," end quote. In the Court's view, these rules incorporate obligations which are essentially of an erga omnes character. The Kingdom considers these principles, furthermore, to be a peremptory norm of general international law, and would like to refer in this respect to the conclusion of the International Law Commission to include the basic rules of international humanitarian law in its list of rules of jus cogens. The Kingdom submits that, while international humanitarian law is applicable in situations of occupation, international humanitarian law does not contain rules for determining whether an occupation is lawful or unlawful as such, even if breaches of the rules are serious in nature. Rather, irrespective of its legality, international humanitarian law regulates situations of occupation once such a situation has arisen in fact. As noted by the Court, and I quote, "Under customary international law, territory is considered occupied when it is actually placed under the authority of the hostile army, and the occupation extends only to the territory where such authority has been established and can be exercised," unquote, as reflected in Article 42 of the Hague Regulations of 1907. As stated before, inherent in occupation is its temporary nature. Under the Hague Regulations, the occupying power shall be regarded only as administrator or usufructuary. After the Second World War, the Fourth Geneva Convention further developed the law of occupation by significantly enhancing the protection of civilians in situations of occupation. As noted by the Court, the intention of the drafters of the Fourth Geneva Convention was to protect civilians who find themselves, in whatever way, in the hands of the occupying power. Furthermore, the drafters of the Fourth Geneva Convention sought to guarantee the protection of civilians in time of war, regardless of the status of the occupied territories. Once an occupation has factually occurred, the occupying power is obliged to act in accordance with the law of occupation. The occupying power has to respect and protect the civilians in the occupied territory who are regarded as protected persons. Protected persons are, inter alia, entitled in all circumstances to respect for their persons and shall at all times be treated humanely. Private property is to be respected. At the same time, such measures of control and security may be taken by the occupying power in regard to protected persons as may be necessary as a result of the war. As noted before, no sovereignty can be established over occupied territory, and occupied territory may not be annexed. In this regard, an important provision under the law of occupation is that the occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies. Under international criminal law, such transfers, directly or indirectly, by the occupying power, constitute a war crime, as reflected in the Rome Statute of the International Criminal Court. It is also prohibited to deport protected persons from the occupied territory. The Kingdom underscores that all high contracting parties to the Geneva Conventions are under an obligation to ensure respect for the Geneva Conventions, with reference to Article 1 common to those conventions. As noted by the Court, and I quote, "Every state party to that convention, whether or not it is a party to a specific conflict, is under an obligation to ensure that the requirements of the instruments in question are complied with," unquote. Mr. President, in relation to international human rights law, the Kingdom would first note that this body of law continues to be applicable during situations of armed conflict, including occupation. The Court has come to this conclusion in its advisory opinions on legality of the threat or use of nuclear weapons and construction of a wall. It added, in the case concerning armed activities on the territory of the Congo, that, and I quote, "International human rights instruments are applicable in respect of acts done by a state in the exercise of its jurisdiction outside its own territory, particularly in occupied territories," end of quote. The International Law Commission has equally concluded that human rights treaties continue to apply during armed conflict in its 2011 draft articles on the effects of armed conflicts on treaties. It follows that an occupying power, for the purposes of international humanitarian law, is bound to respect, protect, and fulfill the human rights of all those within the occupied territory. The obligations owed by states under rules of universally applicable customary international human rights law are of an erga omnes character. The Court has confirmed this in the Barcelona Traction case, considering that erga omnes obligations, and I quote, derive, for example, in contemporary international law from the principles and rules concerning the basic rights of the human person, unquote. According to the Court, this includes the prohibitions of genocide, slavery, and racial discrimination, as well as the prohibition of torture. Certain rules of international human rights law can moreover be characterized as peremptory norms of international law. According to the International Law Commission, this includes the prohibition of genocide, the prohibition of torture, the prohibition of slavery, and the prohibition of racial discrimination and apartheid, as well as the right of self-determination. Mr. President, both questions before the Court concern the legal consequences of ongoing violations of rules of international law. Several of these rules are, as indicated, peremptory norms of general international law. As we have stated before, all such peremptory norms are applicable erga omnes. I will now address the additional legal consequences for all states and international organizations in the event of a serious breach of such a peremptory norm. It being noted that these consequences are additional to the regular obligations arising from the commission of an internationally wrongful act. The rules on the legal consequences for states when a serious breach of a peremptory norm occurs are reflected in Articles 40, 41 and 48 of the Articles on the Responsibility of States for Internationally Wrongful Acts. The relevant provisions for states and international organizations may be found in Articles 41, 42 and 49 of the draft Articles on the Responsibility of International Organizations. According to the Kingdom, these provisions reflect customary international law. These legal consequences may be divided in two categories: substantive consequences and procedural consequences. I will only address the Articles on State Responsibility in my statement. However, it is equally applicable to the draft Articles on the Responsibility of International Organizations. Article 40 of the Articles on State Responsibility defines a serious breach as a gross or systematic failure by the responsible state to fulfill its obligation under a peremptory norm. Article 41 stipulates the particular substantive consequences of such a breach, not only for the responsible state, but for the international community as a whole, including that state. In sum, states shall cooperate to bring the serious breach to an end, shall not recognize as lawful a situation created by such breach, and shall not render aid or assistance in maintaining the situation. The Court has confirmed the binding nature of the rules reflected in Article 41 in jurisdictional immunities. The Court has on multiple occasions pronounced on the legal consequences of serious breaches of norms affecting the international community as a whole. In Barcelona Traction, the Court established that obligations owed towards the international community as a whole are the concern of all states, and that, and I quote, in view of the importance of the rights involved, all states can be held to have a legal interest in their protection. They are obligations erga omnes, end of quote. The Court further confirmed these obligations in its advisory opinions on Namibia, the construction of a wall, and the separation of the Chagos archipelago. Thus, the jurisprudence of the Court supports the obligations reflected in Article 41 of the Articles on State Responsibility. The Court has also identified the obligation of non-recognition and the prohibition to render aid and assistance, and the obligation to cooperate to bring the consequences of the serious breach of a peremptory norm to an end. As to the specific implementation of these rules, the Kingdom observes the following. First, the obligation to cooperate to bring to an end the consequences of the serious breach of a peremptory norm will, in most cases, and particularly in cases concerning self-determination and decolonization, be implemented most effectively through the United Nations. However, should cooperation in the context of the United Nations fail to materialize, or should the United Nations be unable to take appropriate action, states are not relieved from their obligation to cooperate to bring the consequences of the breach to an end. In that case, they are obliged to seek cooperation through regional or bilateral fora. Second, the obligation not to recognize as lawful the situation brought about through the serious breach of a peremptory norm must take into account the exceptions to that rule as formulated by the Court in the Namibia advisory opinion. Third, the rendering of unlawful aid and assistance contrary to the prohibition thereto does not give rise to international responsibility of the aiding or assisting state for the underlying situation or internationally wrongful act, but only for its unlawful aid or assistance. Fourth, the obligation not to render aid or assistance includes an obligation not to undermine measures, including sanctions, taken by other states in their endeavor to bring to an end the serious breach of a peremptory norm. In particular, when the state undermining those measures does so knowing that its conduct contributes to the maintenance of the unlawful situation. Finally, it is our view that a serious breach of a peremptory norm entitles states, other than the injured state, to take a countermeasure against the responsible state as a legal consequence of that breach. Such resort to countermeasures by a non-injured state must be in accordance with the customary rules on countermeasures, including the conditions of proportionality and reversibility. As a final observation, it may be recalled that the Kingdom considers that all peremptory norms are applicable erga omnes. Therefore, the procedural legal consequence of a serious breach thereof is that all states and international organizations have legal standing to invoke responsibility for such a breach. They may claim cessation of continuing internationally wrongful acts, assurances and guarantees of non-repetition, and performance of the obligation of reparation. A claim concerning reparation is restricted in the sense that it must be in the interest of the injured state or international organization or of the beneficiaries of the obligation breached. And such beneficiaries may include individuals and peoples. Mr. President, this brings me to the end of my statement. We sincerely hope that your advice will contribute to achieving peace in the Middle East. Thank you, Mr. President.
I thank the delegation of the Netherlands for its presentation. I invite the next participating delegation, Bangladesh, to address the court. Let me call upon His Excellency, Mr. Riyaz Hamidullah, to take the floor.
Mr. President, members of the court, it's my distinct honor and privilege to address the principal judicial organ of the United Nations on behalf of the People's Republic of Bangladesh and participate in these advisory proceedings on the legal consequences arising from the policies and practice of Israel in the occupied Palestinian territory, including East Jerusalem. Bangladesh fought for 23 long years to gain her independence and finally achieved it through a bloody war in 1971, during which 3 million people had to sacrifice their lives. In the early days of independent Bangladesh, in 1972, our father of the nation, Bangabandhu Sheikh Mujibur Rahman, said, I quote, "The world is divided in two parts, oppressors and oppressed, and I am with the oppressed," unquote. As Bangladesh pursued her own self-determination, our constitution mandated us to support oppressed peoples worldwide who are fighting imperialism, colonialism, or racism. This duty is outlined in Article 25C of our Constitution. In accordance with this duty, Bangladesh is participating in these advisory proceedings to contribute to the realization of the right of the Palestinian people to self-determination. We aim to achieve this by providing this court with our perspectives on the questions asked by the UN General Assembly in the current request for an advisory opinion. Bangladesh has long reiterated the call to end Israel's occupation of Palestine and to achieve a lasting and permanent solution which entails the establishment of a sovereign and independent Palestinian state along the pre-1967 borders, with East Jerusalem as its capital. We firmly believe that the court must heed the long overdue call to holistically examine Israel's occupation and render an opinion on the legal status of the occupation as a whole. As we heard in this very hall just last month, Gaza has been described as a living hell. On 20th May 2021, even before the ongoing war, Mr. Antonio Guterres, the UN Secretary General, said, I quote, "If there is a hell on earth, it is the lives of children in Gaza," unquote. I stand before the court also in the context of the fast-developing circumstances in Rafah, with grave humanitarian implications for the 1.4 million Palestinian people, nearly half of them children. The ongoing war represents one of the most shameful catastrophes in the history of the modern era. The UN agencies and other humanitarian aid organizations on the ground have warned of a humanitarian disaster engulfing the tiny enclave of 2.3 million people with shortages of food, fuel, drinking water, and medicines worsening by the day. The killing of thousands of innocent civilians, particularly children, the destruction of their homes, the occupation of their ancestral lands, and the deliberate obstruction of their access to food and water all constitute blatant violations of international law and serve as textbook examples of ethnic cleansing. Bangladesh firmly believes that an advisory opinion on the questions posed by the General Assembly would undoubtedly represent a critical and logical step towards ending the illegal occupation. The dismantling of this occupation would, in turn, address the root cause of Israel's violent subjugation of the Palestinian people. We elaborated on these matters and the underlying reasoning in our submissions before the Court, Mr. President, on 24 July and 25 October last year. It is pertinent to recall that just 4 months back, the UN Special Rapporteur on the situation of human rights in the occupied Palestinian territories, Francesca Albanese, in her report, brought up several appalling facts. I would consider it apt to quote one pertinent aspect, and I would quote, "In the occupied Palestinian territory, the fundamental right to life is under threat, as indicated by the mortality rates of Palestinian children. The neonatal mortality and infant mortality rates in the occupied Palestinian territory are respective 9.3 and 12.7 per 1,000 live births, rising to 14.8 per 1,000 live births for children under 5, while in Israel they are 1.7, 2.7, and 3.4 per 1,000 live births. In addition to direct attacks on the right to life, Palestinians also endure structural violence and racial discrimination, which impedes their full development." Unquote. These structural violence of the occupation and the deliberate and excessive use of force against the Palestinians are indeed not limited to the recent events in Gaza. As the Special Rapporteur, Ms. Albanese, stated in her 2023 report, I quote, "The spectre of death looms as a dominant element in the lives of Palestinian children. This reality exerts a psychosocial toll on those who manage to survive, as pointedly expressed by Oadia, a 14-year-old girl. I quote, as she said, "Fearing death does not prevent you from dying, but it prevents you from living." Unquote. Thousands of Oadias keep crying in silence, deprived and disenfranchised for decades. Ending the occupation would necessarily bring an end to the violence that is exercised upon Palestinians on a daily basis. However, there is no end to the occupation in sight, nor is it likely to end through political means alone. It has become interminable. That much was all but confirmed by Israel's Prime Minister, Mr. Benjamin Netanyahu, on 18 January 2024. The Court's intervention to us is therefore both timely and necessary. As I proceed with this oral statement, I wish to address whether the occupation of Palestinian territory by Israel is illegal or not. Even though the great majority of states participating in these proceedings, including Bangladesh, are firmly convinced that the occupation is illegal, we note that 2 states contend that it is not. Next, I will state the legal consequences that, in our view, derive from the illegal status of the occupation. On Israel's illegal occupation, Mr. President, members of the Court, the fundamental question posed by the UN General Assembly regarding the legality of the Israeli occupation is grounded in established international norms and legal principles. The State of Palestine, in its written statement, underscores the colonial and acquisitive nature of the occupation, emphasizing its deleterious impact on the Palestinian people. The occupation characterized by persecution, racial discrimination, and apartheid, stands in clear violation of three preemptory norms of international law: the right to self-determination, the prohibition of acquiring territory by force, and the prohibition of racial discrimination and apartheid. Numerous submissions have echoed these sentiments, highlighting the temporary nature of belligerent occupation as mandated by international law. The annexation of occupied territory and the settlement of the occupying power's nationals in the occupied area are explicitly prohibited, constituting illegal acquisition of territory under the UN Charter and relevant UN resolutions. Israel's prolonged occupation, coupled with its policies of colonization and annexation, underscores its illegality under international law. These actions not only contravene the UN Charter, but also violate general international law, including the preemptory norm prohibiting the acquisition of territory by force. Furthermore, arguments put forth by states and international organizations reject any justification for Israel's occupation on grounds of self-defense. The occupation violates fundamental principles of international law, including the right to self-determination and the prohibition of acquiring territory by force. The advisory opinion on Wall, which concluded that Israel cannot rely on self-defense to justify its actions, reinforces the notion that the occupation cannot be justified under international law. While the countries supporting Israel in these advisory proceedings have primarily focused on jurisdictional questions, a few states have addressed the merits of the occupation. One contends that an occupation can never be unlawful, regardless of violations of international humanitarian law. However, this argument stands in contravention of established legal principles and has been widely found to be incorrect. Switzerland's distinction between the law of occupation and the legality of occupation further elucidates the legal framework surrounding the issue. An occupation that involves annexation or de facto control of the occupied territory constitutes an illegal acquisition of territory by force as prohibited under international law. Ultimately, Israel's occupation, characterized by its acquisitive, colonial, and annexationist nature, represents a clear violation of international law. It serves as a means for the illegal acquisition of territory and must be brought to an immediate and unconditional end. I may also recall the UN Security Council Resolution 2334 of 23 December 2016, which reaffirmed the obligations of Israel, the occupying power, to abide scrupulously by its legal obligations and responsibilities under the Fourth Geneva Convention in regard to the protection of civilian persons in time of war. That Security Council resolution also condemned all measures aimed at altering the demographic composition, character, and status of the Palestinian territory occupied since 1967, including East Jerusalem, including, inter alia, the construction and expansion of settlements, transfer of Israeli settlers, confiscation of land, demolition of homes, and displacement of Palestinian civilians in violation of international humanitarian law and relevant resolutions. Israel has flagrantly violated this and all other Security Council resolutions, and it continues to do so in furtherance of permanently maintaining its illegal occupation of Palestinian territory. At a more granular level, may I refer to the approaches of assessing legality advanced by the former UN Special Rapporteur, Michael Link, in his 2017 report to the UN General Assembly, and the current Special Rapporteur, Francisca Albanese, in her 2022 report. These are apposite and relevant to the Court's task in this case. The two approaches overlap and interrelate, but ultimately provide two pathways for determining the legal status of the occupation. I may humbly request the Court to consider the Link report, where he proposed a four-part test for determining the legality or illegality of an occupation. The special rapporteur's approach also fits within the parameters of the Court's advisory opinion on the legal consequences for states of the continued presence of South Africa in Namibia. That opinion arose out of Security Council resolution declaring South Africa's continued presence in Namibia illegal. If South Africa's mandate could be found to be illegal due to its violation of the applicable international legal principles, so too can Israel's occupation by reason of its violation of the same principles. Therefore, applying one or both of these frameworks, which Bangladesh endorsed for the reasons stated in our written submissions, we respectfully submit that Israel's occupation is undoubtedly illegal. I would now turn on the legal consequences. Mr. President and members of the Court, there is a broad consensus that Israel, through its denial of the Palestinian people's right to self-determination, has violated preemptory norms of international law. These violations include persecution, racial discrimination, and apartheid against Palestinians, as well as the occupation, colonization, and annexation of Palestinian land. These systematic breaches severely undermine the rights of Palestinians as a people and Palestine as a state, while also hindering the prospects for a just and lasting peace in accordance with international law and relevant UN resolutions. Consequently, international law mandates the complete, unconditional, and immediate cessation of these internationally wrongful acts. All states and international organizations that have condemned Israel's conduct agree that these systematic and grave breaches carry legal consequences for Israel as the responsible state, other states, and the United Nations and other intergovernmental organizations. So, on legal consequences for Israel, first, Israel must cease all acts preventing the exercise of the right to self-determination by the Palestinian people, including rescinding discriminatory laws and measures. This cessation includes withdrawing occupation forces, dismantling illegal structures such as settlements and the wall, and repealing annexation-related legislation. And secondly, Israel must provide reparations for the damages caused and guarantee non-repetition. On the legal consequences of all other states, first, all states must ensure the immediate cessation of any impediment to the exercise of the Palestinian people's right to self-determination and uphold the prohibition of acquiring territory by force and racial discrimination and apartheid. And secondly, states must not recognize the illegal situation resulting from Israel's wrongful acts, including in Jerusalem, and must not provide aid or assistance to maintain this situation. Cooperation is essential to ensure Israel's compliance with international law and humanitarian standards. On legal consequences for the United Nations, first, the UN General Assembly and the Security Council should consider further action to immediately end the Israeli occupation and remove obstacles to Palestinians' rights, including self-determination. And secondly, immediate action is necessary to end the system of apartheid set up by Israel, with relevant UN resolutions implemented without delay. Mr. President, distinguished members of the Court, the promise of a Palestinian state based on a diplomatic settlement grounded in law has been a prominent feature of the international agenda since 1948. 75 years later, there exists a vast body of practice, state practice and opinion jurists that emphatically support the Palestinian people's right to an independent state. The UN Security Council and the General Assembly have adopted numerous resolutions since 1948 on the question of Palestine, recognizing, among other rights, the right of return for Palestinian refugees and the right of Palestinians to establish an independent state along the pre-1967 borders. Additionally, both the UN General Assembly and the Human Rights Council have acknowledged the Palestinian people's right to self-determination. Importantly, in 2004, this court, in its advisory opinion on the wall, explicitly affirmed the Palestinian people's right to self-determination under international law. Bangladesh, drawing on our agonizing struggle for independence, recognizes how the state of Palestine consistently and conclusively reaffirmed her commitment to a peaceful solution. This solution, in accordance with international law and based on the aforementioned terms of reference, aims to ensure the fulfillment of the Palestinian people's inalienable rights under international law. These rights include self-determination, the right of return, the realization of independence and sovereignty of the state along pre-1967 borders, with East Jerusalem as its capital, and the aspiration to live side by side in peace and security with Israel. The Court's steadfast commitment to universally uphold rule of law, coupled with its principled stance on the legality of Israel's half-century temporary occupation of the occupied Palestinian territory, would shine a light of hope on the beleaguered Palestinian people. A decisive determination by the Court of the illegal status of the Israeli occupation of Palestinian territory and the legal consequences that arise from such status, including an immediate, unconditional, and complete end to the occupation, would help secure the identity, respect, dignity, and existence for the present and future generations of the Palestinian people in a state of their own, at peace with Israel. Mr. President, members of the Court, Palestinians are no expendable people. As much as this advisory opinion involves legal questions, it poses an exceptional moral issues for the humanity. I stand before the Court as Bangladesh deem it our sacred duty to uphold international law as well. On behalf of Bangladesh, I therefore respectfully request the Court to give full consideration to the importance of an advisory opinion at this critical moment. I'd like to thank you, Mr. President, as well as the distinguished members of the Court for granting Bangladesh this opportunity to participate. Thank you.
I thank the delegation of Bangladesh for its presentation.
I invite the next delegation, Belgium, to address the court and call to the podium Mr. Piet Herbut. You have the floor, sir.
Mr. President, honourable members of the court, it is a great honour for me to appear before you as agent for the Kingdom of Belgium in these oral proceedings concerning the request for an advisory opinion, which was submitted to you by the United Nations General Assembly in its resolution of the 30th of December 2022. Belgium is grateful to the Court for having given it the opportunity to be heard in these advisory proceedings. In light of the time available to it, Belgium shall limit its submissions to the matter of settlement and its legal consequences. As Belgium has already had the opportunity to underline, notably when it addressed the United Nations Security Council, Israel has established a veritable policy of settlement in the occupied Palestinian territory for decades now. This policy is carried out by means of a series of associated measures which are indissociable from establishment of the settlements themselves. Now, with your leave, I will first set out the general relevant legal framework. Relevant when it comes to the matter of settlement of the occupied Palestinian territory. I will then spend a moment on the unlawful nature of the establishment of the colonies. Professor Vaius Koutroudis will then look at the relevant rules with respect to the unlawfulness of the policy of settling the occupied Palestinian territory and the related measures adopted by Israel in that connection. And he will conclude by setting out briefly the legal consequences of the violations of international law that we shall identify or that have been identified. Mr. President, Belgium will start its statement by a brief recall of the relevant legal framework relevant to the issue of settlement. Now, Israel's policy of settlement is being implemented in the general context of the prolonged occupation of the Palestinian territory. Now, in its advisory opinion of the 9th of July 2004 on the legal consequences of the construction of a wall in the occupied Palestinian territory, the court provided the following clarifications regarding the general legal framework regarding the occupation in question. Firstly, the Palestinian territory had been controlled by Israel since 1967, including eastern Jerusalem, and that this territory was an occupied territory. Secondly, the illegality of territorial acquisition by force of the occupied Palestinian territory was established. And this rule prohibits the annexation of territory by Israel, including annexation of a de facto nature. Thirdly, Article 51 of the UN Charter was found by the court to have no relevance in this case because the territory in question was a territory occupied by Israel. Fourthly, the Palestinian people enjoyed a right to self-determination. Fifthly, the instruments relative to the protection of human rights applied in an extraterritorial fashion, including in the situation of an armed conflict and military occupation. So from what I have just said, it is clear that all territory effectively controlled by Israel beyond the 1967 borders is an occupied territory, and that its annexation in whole or in part, be it de jure or de facto, was prohibited under international law. And therefore, the following apply to the occupied Palestinian territory. First of all, the rules of treaty-based or customary nature of international humanitarian law, in particular those which are set out in the settlement annexed to the Fourth Convention of The Hague of 1907, as well as all of the rules of the Fourth Geneva Convention of 1949. Also, the following apply: the right to self-determination and rights relative to the protection of human rights. In the case of prolonged occupation, human rights are of a particular importance when it comes to protecting the occupied population. In this connection, it should be noted that the term prolonged occupation does not relate to a specific legal category to which different rules apply. In other words, the same rules apply to all occupations, be they prolonged or not. The prolonged nature of an occupation does not have an effect on the applicability of the rules, but rather on their application. And so it is, for example, that the longer an occupation persists, the more difficult it becomes to invoke exceptions related to the military necessities of the occupying power, which are such exceptions being provided by certain rules of international humanitarian law. It is also ever the more difficult to invoke derogations related to the requirements of those instruments which protect human rights. Similarly, the longer the occupation, the more broadly the obligations, the positive obligations of the occupying power must be interpreted. These obligations are obligations regarding conduct. The states must deploy all means reasonably available to them to fulfill them, and a situation of prolonged occupation and in a situation of prolonged occupation, the control established implies that the occupying power has more means available to it to meet the positive obligations deriving from international humanitarian, international human rights law. Now, having made this or given this brief presentation of the general legal framework, I will now spend some time looking at the unlawful nature of the establishment of these settlements in the occupied Palestinian territory. Paragraph 6 of Article 49 of the Fourth Geneva Convention of 1949 provides that the occupying power, and I quote, the occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies. End of quotation. And in its advisory opinion of 2004, your court found that, and I quote, Israel has conducted a policy and developed practices involving the establishment of settlements in the occupied Palestinian territory contrary to the terms of paragraph 6 of Article 49. End of quotation. Now, in line with these findings of the court, Belgium avers the unlawful nature of the establishment of settlements in the occupied Palestinian territory under the Fourth Geneva Convention. Furthermore, Belgium considers that establishment of the settlements was inconsistent with the relevant resolutions of the Security Council. Now, given that I do not have much time, I will simply point you to Resolution 2334 adopted on the 23rd of December 2016. Now, based on the criteria set out by your court in its advisory opinion on Namibia, this resolution is certainly one which sets out the obligations bearing upon members of the United Nations. And so, having stated that the creation of settlements constituted a flagrant violation under international law, the Security Council, and I quote, reiterated its demand that Israel immediately and completely cease all settlement activities in the occupied Palestinian territory, including East Jerusalem. End of quotation. Now, in light of the clear wording of the paragraph I've just quoted, it is clear that Israel's pursuance of the settlement policy contravenes Resolution 2334 issued by the Security Council. Now, that brings me to the end of the second point in these oral presentations by Belgium. Mr. President, with your leave, I will now offer the floor to Professor Vaius Koutroulous, who will continue the presentation.
I thank Mr. Herbout. I now give the floor to Professor Vaius Koutroulous. You have the floor, sir.
Mr. President, honourable members of the court, it is a great honour for me to appear before you for the first time on behalf of the Kingdom of Belgium. I will now continue on with Belgium's oral submissions by stating the relevant rules which are relevant to the unlawfulness of the settlement policy, the policy of settling the occupied Palestinian territory, and then I will conclude with the legal consequences of the violations identified. Now, in its Resolution 2334 of 2016, the Security Council very clearly emphasizes the multidimensional nature of the policy of settling the occupied Palestinian territory. Along the same lines, Belgium, in its interventions before the Security Council, stressed the relationship between the establishment of settlements and its associated measures which are an integral part of this true policy of illegal settlement. It is therefore impossible to legally analyze this settlement policy without considering the specific measures deployed to realize it within the general context in which it is being applied and the effects it produces. The measures used to realize this settlement policy, taken individually, are problematic when it comes to the law which applies to the occupied territory In other words, and in particular, international humanitarian and international human rights law. In this respect, Belgium has always condemned, in particular, the use of violence by the settlers against the occupied Palestinian population, and wishes to highlight Israel's obligation to put an end to the violence and to punish its perpetrators. More fundamentally, the policy of settlement aims to bring about an alteration of the demographic composition of the occupied Palestinian territory and its status as a territory itself. In this regard, this policy conflicts with various fundamental rights, or fundamental rules rather, of international law. I will successively walk you through the prohibition on the acquisition of territory by force, the right to self-determination, and the principle of non-discrimination. First of all, the settlement policy flies in the face of prohibition of the acquisition of territory by force. This prohibition is an integral part of the prohibition on the use of force, which is set out in paragraph 4 of Article 2 of the United Nations Charter, Resolution 2625/25 of the UN General Assembly, as well as paragraph A of Article 3, that is to say, the definition annexed to Resolution 3314/29, resolution of the General Assembly. Now, in its advisory opinion of 2004, your court confirmed the applicability of the prohibition on the acquisition of territory by force to the occupied Palestinian territory. This prohibition covers both the de jure and the de facto annexation. The measures adopted by Israel as part of its policy of settlement aim to create irreversible facts on the ground and to consolidate its control over the territory concerned by establishing settlements. These measures thereby create a situation in which a fait accompli, which resembles a de facto annexation, is brought about. Such a situation as defined by this court in the advisory opinion of 2004. Secondly, the settlement policy is inconsistent with the right of the Palestinian people to self-determination enshrined in the United Nations Charter and reaffirmed in the General Assembly's Resolution 2625/15, as well as the first article of the International Covenant of Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights of 1966, to which, in the case of both covenants, Israel is party. Resolution 2625/15 specifies that the fact of submitting peoples to subjugation, to domination or foreign exploitation constitutes a violation of the right to self-determination, and that states have a duty to refrain from using any coercive measures that would deprive peoples of their right to self-determination. Now, in its advisory opinion of 2004, your court found that the right to self-determination had been violated. In doing so, it paid particular attention to the measures bringing about, and I quote, the departure of Palestinian populations from certain areas, end of quotation, and also paid particular attention to alterations to the demographic composition of the occupied Palestinian territory. Similarly, in its report published on the 14th of September 2022, the Independent International Commission created by the Human Rights Council and tasked with investigating or conducting investigations in the occupied Palestinian territory, including Eastern Jerusalem and in Israel, underlined that, and I quote, the choice of location of certain new settlements further reduces the likelihood of an end to the occupation and violates the right of Palestinians to self-determination. End of quotation. It follows from this, from what I have said, that the adoption of coercive measures in connection with the policy of settlement aims to alter the status and the demographic makeup of the occupied Palestinian territory, and that it runs counter to the right of self-determination. Thirdly, the policy of settlement raises serious concerns with respect to the principle of non-discrimination. Indeed, the establishment of settlements is intrinsically linked to the establishment of the two distinct institutional and legal systems, one for the settlement residents and the other for the Palestinian population of the occupied territory. The Independent International Commission of Inquiry, which was mandated to investigate in the occupied Palestinian territory, including Eastern Jerusalem and in Israel, as well as the Committee on the Elimination of Racial Discrimination, have underlined the problematic nature of the measures concerned with respect to the principle of non-discrimination. And therefore, and this will bring me to the end of this part of the Kingdom of Belgium's oral submissions. Thus, the settlement policy is problematic with respect to the prohibition on the acquisition of territory by force, the right to self-determination, and the principle of non-discrimination. I shall now turn my attention to the fourth and final point in our oral submissions, and that is the legal consequences of the violations which we have identified and have been identified. I will start with the legal consequences for Israel before spending some time on the legal consequences for third states and international organizations. As an introductory comment, Belgium would like to underline the fact that that several of the rules mentioned before are Jews, Cogan's norms of general international law. Consider, for example, the right to self-determination and the prohibition on the use of force, which includes prohibition on occupation and annexation of territory by force. Therefore, no circumstance excluding unlawfulness can be invoked to justify their violation. For Israel, the violations identified lead to consequences provided for in the customary rules of international responsibility, which are codified in the articles concerning the international responsibility of states, which were adopted by the International Law Commission in 2001. It is a matter of an obligation to end an ongoing violation, an obligation of reparation, as well as the obligation to provide assurances and guarantees of non-repetition. Specifically concerning the policy of settlement, with respect to the ongoing nature of the violation, Belgium refers in particular to Israel's obligation to end all settlement activity, as was affirmed in the advisory opinion of 2004, the obligation to make reparation should first and foremost take the form of restitution. In other words, inter alia, the dismantlement of the settlements, the annulment of legal acts concerning the settlement policy, and the restoration of property requisitioned or expropriated in carrying out this policy. This is also the option which is preferred in the Security Council Resolution 2334 of 2016. Now, as regards third states, their obligations are based on several rules of international law. In other words, rules relevant to the international responsibility of states. Also the obligation to enforce international humanitarian law and the right to self-determination. Firstly, as regards grave violations of Cogan's norms of international law, the states must not recognize as legal the situation arising from the states must not recognize as legal the situation or a situation arising from a grave violation of a peremptory norm. States must not render aid or aid or abet in maintaining the unlawful situation created by a serious violation of a peremptory norm and must cooperate to end the violation. Secondly, as regards violations of humanitarian international law, the obligation under treaty law and customary law to enforce these rules is set out in the first common article of the 4 Geneva Conventions. This obligation also bears on third states, and it includes both negative and positive obligations. The obligation to not aid or abet the commission of a violation is an example of such a negative obligation, and the obligation to take measures to incite the warring parties to cease violations of international humanitarian law is an example of a positive obligation. Thirdly, a similar obligation bears upon third states as regards the right to self-determination. Indeed, Resolution 2625 provides that, and I would cite, all states have a duty to promote jointly with other states or separately the achievement of the principle of the equality of the rights of people and their right to self-determination. End of quotation. Resolution 2334 of 2016 provides a specific example of enforcement of such obligations. In that resolution, the Security Council calls upon all states to distinguish in their relevant dealings between the territory of the State of Israel and those territories occupied since 1967. Now, that call reflects the obligation to conduct dealings, including economic and trade dealings, in such a way that there is no recognition, no assistance, and no contribution provided to maintain the unlawful situation of the settlements. Finally, and this will be the last point made by the Kingdom of Belgium, the legal consequences associated to the serious violations of the peremptory norms that I have mentioned heretofore also apply to international organizations. Now, of course, international organizations operate within the bounds of their remits, but where they have discretion to act, they must exercise it to end serious violations of peremptory norms. Mr. President, ladies and gentlemen, members of the Court, this concludes the oral submissions of the Kingdom of Belgium. I thank you for your kind attention.
I thank the delegation of Belgium for its presentation. That brings to an end this morning's hearing. The Court will reconvene this afternoon at 3 p.m. to hear Belize, Bolivia, Brazil and Chile. Hearing stands adjourned.